So here we go. Thanks, Liz. And thank you, everybody who has joined us. As I was saying, this is my first webinar, so bear with me if we run into any technical glitches. We'll quickly get them fixed. For those of you who joined in on Tuesday, you'll know that it is our intention to continue these webinars on weekly, giving you information with respect to all of your estate planning and elder law needs. So today's webinar is focused on estate planning, and I'm going to be talking about Advance Directives. So, okay, so healthcare documents. When we talk about healthcare Advance Directives, the first document that we consider is the healthcare proxy. Healthcare proxy is the document that dictates who should make healthcare decisions for you in the event that you're unable to make those decisions for yourself. Now, it's important to note that in New York, we do not permit co-agents. We only permit one healthcare agent at a time. So if you have a document that names two agents acting together, you're going to want to update that document. You can have a document that allows for successor agents, but not co-agents. Documents named, agents named in a healthcare proxy are going to be empowered to make all healthcare decisions for you, including end-of-life decisions. So it's equally important that you have a conversation with those people that you've chosen and make sure that they know what your decisions would be with respect to treatment and end-of-life decisions. Another document that we always execute with our clients is a HIPAA release form. HIPAA release form is the document that is going to allow those same persons that are named in the healthcare proxy or other people, if you choose, to have access to your confidential medical records. This becomes vitally important, particularly in times like these when we're potentially separated from our loved ones who might be hospitalized and we want to get healthcare information. You need to make sure that you have legal authority to request that healthcare information. We typically also execute with our clients a document called a HIPAA release form. The HIPAA release form is living will. The living will is the document that will outline your wishes with respect to end-of-life decisions. So a living will is simply a document that is a statement of your intent. And what it says is that if a time should come that you have an incurable illness, no hope of recovery, that you do not wish to be kept alive artificially, the healthcare agent will be tasked with making that decision. But what the living will does is it acts as a statement of your wishes and clear evidence of what you would want if a time ever came that you could not make end-of-life decisions on your own, that your family members or friends, whoever you named as your healthcare agent, would be able to make those decisions for you. So if you have those three documents, you should be in good shape with respect to healthcare decision making. Another document that some of my clients execute is something called a MOLST form, MOLST, Medical Order for Life-Sustaining Treatment. This is a document that will take the healthcare proxy, end-of-life decision, DNR directives, and put them all into one document. This is a document that you would execute, however, with your physician, not with your attorney. It's a good idea for people who have chronic illness, significant treatment issues, and require everybody to sort of be on the same page with respect to what the end-of-life treatment is and how you want your affairs handled. A MOLST form is not a document that a otherwise well and healthy person would execute, but it is a document that somebody would execute who either has a chronic terminal illness or there's an expectation that they are towards the end of their life. It is an end of life advance directive. So if anybody has any questions with respect to healthcare documents, I could answer them at this point. Liz, are there any?
I don't have any questions at the moment.
Okay, and the video is okay now?
Yep, much clearer. Thank you.
Thank you. Okay, so in addition to the healthcare proxy with respect to advance directives, the other document that we recommend our clients to have is the power of attorney document. So a durable power of attorney in New York State, everybody should be signing the same basic document. In our office, we have taken great effort and lengths to make sure that we've modified that document to include all of the power that a person might need. So power of attorney is the document that names another person or more than one person to step into your shoes and act as if they are you with respect to all business and financial decisions. Power of attorney is valid only during your lifetime. So when you pass away, the power of attorney becomes invalid. But during your lifetime, a very, very important document. So the document itself is a two-part document. The first part of the document is the general power of attorney. And that document gives another person or more than one person the ability to write checks, do banking transactions, contact the IRS, deal with tax matters, deal with your retirement account. There are a whole litany of powers that are given in that power of attorney. There is a place within the document where you can make modifications. In our office, we've added approximately 35 modifications, many of those modifications having to do with advanced estate planning, advanced Medicaid planning. Our recommendation is typically to our clients to give all of the powers. However, it's a document that can be modified to your needs and your wishes. The second part of the document is the statutory gift rider. The statutory gift rider is the document which allows your agents to gift on your behalf. Now, for under the power of attorney, when we're talking about gifting, certainly we're talking about basic gifting, birthday gifts, Christmas gifts, wedding gifts. But what we're also speaking about is any movement of money. So where we often use the gift rider under the power of attorney is when we're dealing with estate planning and Medicaid planning. Because any movement of an asset or money from one individual to another individual to a trust is considered a gift. So in order to transact in that way, it's necessary that the statutory gift rider be executed. So I'm going to give you an example because I think that's probably the best way to understand the issue. Let's say that you have a power of attorney that was drafted many years ago, and it's a basic, simple power of attorney, and you name your spouse as your agent under the power of attorney and your child as the successor agent, and you become ill and you are in a hospital or require, and the expectation is that you require long-term care in a nursing facility. And you come to our office and you want to talk about Medicaid planning. And one of the recommendations might be to transfer certain assets from your name to your spouse's name to avail yourself of some of the Medicaid benefits. And your sick spouse lacks capacity. In the event that there is a power of attorney with a valid executed gift rider, we can use that power of attorney to transfer assets and engage in Medicaid planning. If there is no gift rider on the power of attorney, and the spouse who is ill lacks the capacity to sign documents, then we may be looking at a guardianship in order to effectuate the necessary and required planning. So it's important when signing the power of attorney, when reviewing your older documents, to make sure not only that you have an updated power of attorney, but that the powers in the document are going to give you everything that you need should a time come that you ever need to use it. Now, with respect to who you should name in the power of attorney, you can name anybody that you want. You can name more than one person. You can require that they act together. You can allow them to act independently. You can assign successor agents. There are any number of ways that you can execute a power of attorney. It may be that you decided that you want to have your spouse and your child as power of attorney, but you want either one of them to act. You may decide that you only want your spouse and the kids to act only if a time comes that you can't act for each other. So that's an important conversation to have while looking at these documents and while deciding how best to execute them. Liz, any questions come up for the power of attorney?
We don't have any questions at the moment.
Okay. And everybody can hear all right?
Oh, we just had one question come up.
Great.
Yep, from Daniel. It says, if my spouse is a beneficiary or listed jointly on all financial accounts, do I still need to give them power of attorney?
Yeah, so that's a great question. My answer is yes. So even though your spouse is listed as a beneficiary, and possibly even if your spouse were listed joint, the purpose of the power of attorney is not so much to make sure that the assets go where they need to go when you pass away, but to make sure that if you have some sort of a medical condition or some sort of a life event that renders you unable to manage your own affairs, that somebody has the ability to step in. Now, being joint on the bank account, certainly they can manage those bank accounts. However, being joint on the bank account is not enough. Let's say that you have your husband joint on the bank account and he's the beneficiary on a retirement account, but you need to apply for Medicaid to pay for care, or you need to access information from your pension company or your retirement company. Simply having a beneficiary or a joint owner will not give you that authority. So my answer is yes, even where everything is joint, even where you have a valid will, a power of attorney is incredibly important to make sure that in the event of an incapacity, you avoid the need for a guardianship proceeding, because that's really what we want to avoid. Guardianship proceedings are court proceedings. They are potentially lengthy. They are potentially costly, and they're certainly easily avoidable through a properly drafted power of attorney document. Liz, any other questions come up?
Not right now.
Okay. I'm going to give it a second and then.
For anyone that may have a question, if you are on a desktop or a laptop or maybe your mobile phone, there is a panel. If you scroll over to your right, if you're on a mobile device, if you'd like to type in a question, we'd be more than happy to answer that for you.
Okay. While we're waiting, I think I'll go back and talk a little bit more about the power of attorney document and other reasons that you might need it. When the question was asked if we're joint on everything, the other thing that is often important to point out is that even where you're joint owners on a home, let's say that there was a need to transfer the home for some reason to your spouse or into a trust. Simply being a joint owner does not give you the authority to transfer the full ownership of the house. So that's another reason that we want to make sure that somebody is authorized to make decisions for you. The power of attorney deals also more than just financial accounts, but also deals with your pension company, your former employer, the IRS. So there's a whole host of reasons that we might want to make sure that there is a good and valid power of attorney in place. Another document that you could consider, it's a document called an agent to control disposition of remains. Here we're talking about your funeral arrangements. People often ask me, well, don't we need to put information about our funeral in our wills? And the answer to that is no, you don't need to. The recommendation is to either prearrange and prepay a funeral or execute a document called an agent to control disposition of remains. And in that document, you can not only name somebody to manage your final affairs, but you can specify down to the smallest detail who should manage your final arrangements when that time comes. That's specifically important if there are special arrangements that you want made. I'm going to go back to the healthcare proxy just for a moment. And I just want to clarify that I did say that there are 3 documents: healthcare proxy, living will, and HIPAA release form. In some cases, all 3 of those documents are consumed in one document. That's fine. We like to do them separately because we like to cut down on the confusion. However, it's fine if you have all 3 documents consumed in one document. I also wanted to just speak to next week's webinars, where hopefully we'll be a little bit better in shape with our technology. I think Britt did fine on Tuesday. I'm struggling a little bit with my internet, but help, I hear, is on the way. We'll be speaking next week about trusts. So again, it will be a 2-part webinar, Tuesday and Thursday. We'll be talking about irrevocable trusts, revocable trusts, descendants trusts, special needs trusts. And then the following week, we'll be doing a Medicaid review. So we will keep these webinars going weekly. Liz, is there anything else? Any questions?
I don't have, we have one more question. Yes. Let's see. Can the agent to control disposition be built into the power of attorney?
No, it can't. It's a separate document, but it's a very simple document. The reason that it can't, just so you understand, is that the efficacy, the validity, the legality, everything of the power of attorney dies when the agent dies. So if I sign a power of attorney today, naming my son to act as my agent, and I die next week, that document is no longer valid. So it's important not only to have your advance directives in order, and those are the documents that are going to take care during your lifetime, but to make sure that there's a clear flow over to documents to support your family with respect to your estate and your final arrangements after you die. And those documents are the agent to control disposition of remains, the will, and the trust.
Okay, we have one more question. What kind of modifications do you have on the power of attorney?
Sure. So we have a number of modifications, both in the first part of the power of attorney and the statutory gift rider. Those modifications are mostly there to assist with advanced estate planning and Medicaid planning, but by way of example, to hire home health aides is one of them, to create trust, to terminate trust, to deal with litigation, to sign contracts on behalf of the individual, to deal with the taxing authority, to apply for government benefits. There are about 60 modifications on the power of attorney document that our office provides. We've also recently added a modification that deals with digital assets and digital passwords, and that's become more and more important. So would give your agent the ability to deal with anything that you have that is stored in a cloud or electronic, or gain passwords to banks and things like that.
Okay, we have one more question.
Sure.
Hi, I know you are practicing in New York. Do you work with out-of-state clients with their wills, power of attorneys, etc.?
No. No, we only practice in New York. So we are licensed only in New York, and we practice in New York. Certainly, if you needed a referral in a different state, we'd be happy to help you get to somebody that we thought would be helpful to you.
He says he's a photographer. What happens with my artwork and digital files? I think he's concerned of if he passes.
Right.
Yeah.
Hi. So great question. Those are assets that will have to be dealt with in your will or your trust. If during your life somebody needs to manage those assets, you have to make sure that your power of attorney gives them the authority to do so. So it would be a modification dealing with digital assets and dealing with personal property. If the question is, how do I dispose of them when I die? It would be specifically delineated in your will or your trust and dealt with that way.
And we're about at our mark. Did you have anything else that you wanted to cover?
No, I think we're good, Liz. I apologize for the technical difficulty in the beginning. We're working on it, and as I said, help is on the way. I've got some video equipment coming my way. Be sure to tune in if you're interested to Cooking Show on Monday. I'll look forward to seeing you all there.